So the Supreme Court is now being asked to rule and decide on more Second Amendment cases, which are now going to be impacted by Rahimi. So let's talk about what is now happening. Now, before we jump into this video, I want to thank one of the new sponsors of the channel, which is Patriot Mobile. For 10 years, Patriot Mobile has been the only company in America, the only wireless provider that has Christian conservative values. Patriot Mobile offers dependable nationwide coverage, giving you the ability to access all three major networks. That means that the same coverage you would get from those companies is the exact same that you would get from Patriot Mobile. And you can also then support a company that has the same values as you, which is pro freedom of speech, pro 2A, and pro freedom. I first met Patriot Mobile over at SHOT Show. I met their whole marketing team. I got to have conversations with them, and they seemed like a really cool company. And they were actually sponsoring, SHOT Show, which is a big deal. And also, they are 100% based in the US, which means that if you need to call customer service, they're all here in the US, and I believe most of their team is actually in Texas. So I recommend that you guys check out Patriot Mobile if you're interested. You can go to patriotmobile.com/scholar, or you can call 972-PATRIOT. And if you use the code SCHOLAR, you can get a free activation fee. So again, really excited about this sponsor, a really cool company. They have the same values as us. And if you guys are interested, again, check out those links. Now, as I mentioned in the intro, in this video, we're going to be discussing some huge two-way cases that are now seeking Supreme Court review in light of what just happened in the Rahimi case. The case we're going to be primarily talking about in this video is the Range versus Garland case. This is a case we followed prior, and it's a case that was put on hold because of Rahimi. Now, these cases are important because now you have multiple cases, the Range case and others, which are seeking Supreme Court review and application of Rahimi towards those decisions, and these deal with different issues in different sections of 922G1 and the various restrictions on people being able to possess firearms, maybe because they're subject to federal restrictions because they have a felony, maybe a nonviolent felony, like in the case of Mr. Range. Now, what has happened in the Range case and some of these other cases is there is a renewed call for the Supreme Court to grant review to the Range case and all of these other cases, or at the very least, GVR the Range case in light of what they just said in Rahimi. Now, if you're not aware what this case involves, what this deals with is a Third Circuit en banc panel decision. And ultimately what happened is that 26 years ago, an individual named Brian Range was convicted of concealing some of his income so that he could obtain additional food through food stamps for him and his family. Essentially, he made some false statements on a form when he was applying for food stamps, and he was charged with a felony or a felony equivalent in Pennsylvania. Now, the history of Mr. Range is that he has no other serious criminal issues, no other convictions prior or post this issue. Simply, he just lied on a government form when he was applying for food stamps. However, because of that one incident and that one ancient misdemeanor and that one conviction, the government now bans Mr. Range forever from possessing firearms. Mr. Range is barred from possessing firearms per 18 U.S.C. section 922G1 on account that he has a misdemeanor offense, which is claimed to be a felony equivalent. Mr. Range brought this lawsuit originally before a district court in Pennsylvania against the Attorney General and the ATF. He sought for the federal government to no longer be able to bar him from possessing firearms only because of that one nonviolent misdemeanor that happened 26 years ago. However, the district court on review ruled in favor of the government on a motion for summary judgment. In doing so, the court also used the two-step approach, which again was struck down by the New York State Rifle and Pistol Association versus Bruen case, and then now also in Rahimi. Now, after losing at the district court level, Mr. Range appealed up to the Third Circuit, and on review, a three-judge panel in the Third Circuit issued an opinion upholding that lower court decision. The three-judge panel cited history and tradition in finding that individuals constitutionally entitled to bear arms are only law-abiding, responsible citizens. So there, the Third Circuit three-judge panel found that his misdemeanor equivalent, this nonviolent issue, essentially made him fall outside of the people protected by the Second Amendment. Well, Mr. Range did not quit after that three-judge panel decision, and he sought en banc panel review of that decision. And on review, the en banc panel in the Third Circuit found that 922G1, as applied to Mr. Range, is in fact unconstitutional. So they struck down 922G1 as applied to Mr. Range. Now, in that decision, the en banc panel in the Third Circuit said that the precedent that they had used in the past, the two-step approach, was improper, especially in light of Bruen. They also went on to say that Range's appeal instead requires us to examine who is among the people protected by the Second Amendment. Range claims he is one of the people entitled to keep and bear arms, and that our nation has no historical tradition of disarming people like him. The government responds that Mr. Range was not one of the people, that he has not been part of the people since 1995. So this is one of those really important questions that even before Rahimi was a big debate in some of these lower courts. So the Third Circuit en banc panel struck down this section of 18 U.S.C. 922 G1, and then the government themselves are now filing for Supreme Court review. They filed for Supreme Court review last year, and then this case was put on hold and was trailing behind Rahimi. Now, again, this is important because it's the government themselves who are requesting review of this case, and oftentimes when the government requests review of a case, they get the answer that they want. The Supreme Court will review those cases. We saw that just play out again in Rahimi. Now, in this cert petition, the government argues, and the question they present to the Supreme Court is whether 18 U.S.C. section 922 G1, the federal statute that prohibits a person from possessing a firearm if he has been convicted of a crime punishable by imprisonment for a term exceeding 1 year, complies with the Second Amendment. Now, the Range case went to conference back in November. So last November, it went to conference. And then, like I stated, it was put on hold behind the Rahimi case. But as we know now, we got a decision in Rahimi. And that came out to be an 8-1 decision, with the only dissenting judge being Justice Thomas. And ultimately, what the Supreme Court found is that 922 G8-1, I believe, was in fact constitutional. And now, as a result of that decision, the government here is renewing their call to the Supreme Court for the Supreme Court to grant review to the Range case and some other cases and apply Rahimi to those issues. In the alternative, what the government is also asking is for the Supreme Court to, at the very least, grant, vacate, and remand the case of Range back down to the Third Circuit en banc panel, to the Third Circuit themselves, to reevaluate Range in light of Rahimi. Now, in their recent petition, the government states that now that the court has decided Rahimi, we believe that it should grant plenary review to resolve section 922 G1's constitutionality. In particular, the court should grant the petitions in Doss, Jackson, and either Range or Vincent, consolidate the granted cases for briefing and argument, and hold the remaining petitions pending the resolution of the granted cases. If the court chooses not to take that course, it should grant, vacate, and remand GVR in Range and deny certiorari in the remaining cases. They go on to say that although Rahimi undermines the reasoning of the decisions holding 922 G1 invalid, the present conflict is ultimately to resolve itself without further intervention by this court, and the cost of deferring this court's review would be substantial. Disagreement about 922 G1's constitutionality has already had widespread and disruptive effects. Therefore, they say that the court should grant petitions for writs of cert in Doss, Jackson, and either Range or Vincent, consolidate the granted cases in the briefings and arguments, and hold all those remaining cases for a resolution in whatever case that they grant. Now, you may be asking yourself, why is this important? This is very important because it is likely that the Supreme Court is going to have to move on either the Range case or some of these cases. My hope would be, I think that they at least grant review to the Range case and decide that case in full, fully apply Bruen and Rahimi in light of the facts of Mr. Range, because the facts in the Range case and Mr. Range himself is a much better plaintiff, as opposed to Mr. Rahimi, who had a horrible criminal record. The Range issue here, which is dealing with lying on a government form and food stamps, and then you losing your 2A rights forever. It's a way better fact pattern for us on the 2A side. So I hope that they grant review to the Range case. I think if they just simply GVR the Range case, it could have issues down at the lower court level, but still, I think if you directly apply Rahimi to the Range issue, it still comes out favorable regardless. But I think we need the Supreme Court to fully flush out those issues. For some of these other cases, I think it would be better for those just to be put on hold behind Range. I know some people are very interested in the Vincent case because I believe that deals with issues about people having substances. I believe that's the Vincent case. So that one would also be very interesting, and it would put a lot of the anti-gun side in a very hard situation to have to argue in favor of those prohibitions. Again, it would kind of go against their political leanings, which would be very interesting to see how they argue that in some of their briefs and some of the oral arguments. But again, this is very important. We're seeing a lot develop in a post-Rahimi world after that 8-1 decision. And now we're seeing the government itself move on the Range case. asking for the Supreme Court to grant review to range once again in a lot of these other cases as well. So this is something we'll definitely be watching closely and see how this develops over the next few days and over the next week or so. And as we get more information, I will let you guys know. So if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.